Hi, everyone. Welcome. My name is Mike Larsen, and I am the current president of the B.C. Freedom of Information and Privacy Association. And it's my great pleasure to welcome everyone and to introduce this really interesting event today. This is an event where we have brought in the Information and Privacy Commissioner of British Columbia, Commissioner Michael McEvoy, to speak a bit about some of the transparency and privacy issues that he's seen from his vantage point over the last year. It's the second event of this nature we've done. We did one last year as well, and it's been a chance for us to kind of catch up on what's been going on in the information and privacy field during the pandemic. In what follows, you're going to hear Commissioner McEvoy talk a bit about some of the priorities that his office has seen, issues ranging from privacy in the context of COVID-19 to transparency and how transparency has perhaps suffered and persevered in some ways during the pandemic, as well as some of the interjurisdictional challenges that his office has been facing in concert with collaborators and other offices around Canada and around the world. Issues like the Cambridge Analytica and Clearview AI investigations, the Cadillac Fairview investigation, which point to large-scale and interjurisdictional challenges for information and privacy rights. So I think a really fantastic snapshot of where we stand right now in terms of information and privacy issues. Before I go any further, a little bit about Commissioner McEvoy. He joined the OIPC way back in 2007, and so has had a chance to really watch all the emerging privacy issues and transparency issues of the current context come across his desk at one point or another. Became the commissioner in 2018 and has done investigations of some of the major privacy and information files in recent BC history, and also worked collaboratively, for example, with the UK in the Cambridge Analytica case there as well. So I think he brings an incredible insight to bear in what he has to say here and gives us a good lay of the land, especially, and I want to note this, in the context of some opportunities for some law reform, which is something that we all should be paying close attention to in BC and indeed across Canada. So without further ado, I'll turn this over to Commissioner McEvoy.
FIPA acknowledges with respect the Indigenous peoples on whose traditional territory we conduct activities. While striving to increase privacy protection and access to information for everyone, we recognize that colonization and associated attitudes, policies, and institutions have significantly changed Indigenous peoples' relationship with this land. For many years, those same things served to exclude Indigenous peoples from the privacy protection and access to information afforded to others. FIPA is committed to redressing these historic and continued barriers. And we acknowledge the insight and knowledge of elders past, present, and emergent, and the relationship to this land and these issues.
And without further ado, welcome, Commissioner.
Thank you, Mike, for that introduction. And I'd actually like to begin as well by acknowledging that I'm speaking to you today from the traditional territories of the Lekwungen-speaking people, and also known to us on the South Island, Vancouver Island, as the Songhees and Esquimalt First Nations. It's with deep appreciation that I live and work on this absolutely beautiful territory. I'd also like to thank our hosts, the BC Freedom of Information and Privacy Association, and Mike, to you, and Jason Waiwata in particular, for bringing us together and for inviting me to join with you for this now annual event. I never take for granted, nor should I think any of us, the important role of a strong civil society. It is worth remembering, I think, as Mike pointed to at the outset, that FIPA played a pivotal role in bringing about groundbreaking information and privacy laws in our province some 30 years ago, and ever since has carried on a determined effort to defend and advocate the improvement of those rights. So, given our respective roles, there are times, of course, when we come at things a little bit differently, but we absolutely share common goals of ensuring government accountability and transparency, as well as strong privacy rights for our citizens. So today I wanted to share a few updates with you on the work of my office and the state of transparency and privacy in BC as we see it at the OIPC. If you detect a theme woven into my remarks today, it would be that upholding the information rights of British Columbians requires strong and effective oversight of public and private bodies, especially in times of crisis. So before diving in, here's a little bit of background on the Information and Privacy Commissioner for those of you who are less familiar. The OIPC was established in 1993 providing for the independent oversight of over 2,900 public bodies under the Freedom of Information and Protection of Privacy Act. The legislature added the Personal Information Protection Act to the Commissioner's responsibilities in 2004, with regulatory authority over any private sector organization in BC collecting, using, and disclosing people's personal information. About me, Mike mentioned a few things. I'm a lawyer. I had very early experience with freedom of information because I was an advisor to the Attorney General who piloted the original bill through the legislature back in 1992. Things went full circle for me when I joined the OIPC in 2007, first as an adjudicator, then deputy commissioner before my 6-year appointment as commissioner by unanimous motion of the Legislative Assembly in 2018. And as Mike noted, somewhere in between all of that, I spent time in the UK helping investigate Facebook and what was then an obscure company called Cambridge Analytica. So as the Bon Jovi song goes from the 80s, I'm halfway there in my term of office, and I have to say, not a day goes by that I do not appreciate the honor of serving the legislature and the citizens of our province. It's been, I guess, about a year since I last presented to you, so this is a good catch-up, I think, on matters from the last 12 months, and will hopefully, as Mike noted, leave an opportunity for a few questions as well. So last month, I filed our annual report with the legislature, providing an overview of our work from April 2020 to March of this year. It was a particularly intense time during which our office, like so many others, and others of you out there have experienced, I'm sure, felt the effects of the global pandemic. I have to say, I'm really incredibly proud of our team at the OIPC for delivering uninterrupted service to British Columbians during these uncertain times, and they've done so with commitment, with expertise, and great purpose. You can read the report in its entirety online, but I did want to point to a few of the highlights, and in particular, a number of investigations undertaken in tandem with other commissioners across Canada. In particular, I note our investigations into Clearview AI, Cadillac Fairview, and Life Labs, which raised issues about surveillance, the use of biometrics, and privacy breaches. On the access side, an upswing, though not a significant one, in access complaints were taken in by our office, and we published our office's 6th report card on government's timeliness in responding to access requests, which I also spoke about, I think, with you the last time. It pointed out to the troubling trends about public bodies taking time extensions without lawful authority. I'll briefly share a few other matters with you outside the annual reporting period that might be of interest. With advances in machine learning, guardrails when applying artificial intelligence are essential. This past summer, we issued a call to strengthen regulation and oversight of artificial intelligence in public sector decision-making. We did this in conjunction with the BC and the Yukon ombudspersons, which I think apropos because of the role those offices play in ensuring fair decision-making processes. We released a compliance review into the practices of private liquor and cannabis retailers, and we identified gaps that needed to be addressed with respect to those entities. We also launched an investigation into the Liberal Party of Canada's use of facial recognition for its nominating processes leading up to the federal election. How political parties collect and use your personal information is an important matter. The election was also an opportunity to see where the party stood on access to information. And I have to say, FIPA, Mike, you and your team and across the country should be credited with pressing the different parties on their stance on government transparency. All along, there's been a lot of work for our office in terms of access and privacy on pandemic-related matters, including inquiries, complaints, and applications on how the statutes apply, and around issues such as contact tracing and vaccine passports. A few moments ago, I referred to the importance of oversight of information rights as a critical ingredient for maintaining trust in our democratic institutions. These rights directly affect our ability to scrutinize public policy making, which takes on even greater importance when our society is in any kind of crisis. As my federal, provincial, and territorial colleagues and I stated in a joint resolution we issued this summer, protecting information rights is essential for governments to be held accountable for their actions and decisions, and to maintain the public's trust in times of widespread crisis. So I'd like to look at this issue through the lens of some of the challenges we're currently seeing with our public sector freedom of information and records management systems, as well as the legislative gaps that need to be addressed in both the public and private sectors. I'll start by sharing some observations about how the access to information system has been functioning during the COVID-19 pandemic. We have been looking at the work of a number of public bodies over the past few months, and what follows is a brief review of that survey. The access to information system can be divided into two branches, in my view. First is the one most recognizable to most of you in the audience, which is someone makes an access request to a public body. That body in turn conducts a search for records and thereafter results in a decision on whether and what records to release. The second branch of the system, and one I think that's gained more prominence during COVID, is the proactive release of records. So I need to say this off the top. The pandemic has at points strained the access to information system, particularly for those public bodies and employees working on the front lines to fight the virus, and to whom, of course, we are indebted. In regard to the first branch of access requests, there has been an increase in those requests for some public bodies, and not surprisingly, some of those are connected with health. At least in the initial stages of the pandemic, public bodies in that sector found themselves scrambling to shift resources to address immediate priorities. In one example, we saw a health authority send out a call for records to their finance department, only to discover that staff there had been redeployed to distribute personal protective equipment. That said, for the most part, and despite certain challenges, we believe that public bodies have adapted their processes to the new reality, shifted or added resources for extra support, and have taken advantage where needed of time extensions provided for in the legislation. My staff have also been encouraged by reports from access to information officers in some public bodies who tell us that as a result of the stresses on the system related to COVID, there's actually a greater awareness within their organizations about the importance of FOI and the desire for more collaboration within those organizations to help satisfy requests. As I outlined last year, reasonable flexibility was something my office exercised under Section 10.2 of FIPA to grant limited time extensions to public bodies at the pandemic's outset. It was not carte blanche. Those who utilized the discretion were required to report to me. While we've seen good examples of resilience in maintaining the public's access right during the pandemic, I've also been deeply disappointed that a number of public bodies have simply chosen not to respond to access requests during the pandemic for completely unjustified reasons. For those, we have been forced to investigate and order them to do so. We've had some other cases right now before our office where claims have been made that public bodies are not discharging their legal obligations under FIPA. Well, of course, I can't comment specifically on those files. I can say in a general way, these types of matters will continue to be thoroughly and impartially investigated and adjudicated by my office. The second branch of the access to information system, the proactive release of records by public bodies, has gotten far less attention until very recently. Now, I can't order proactive disclosure of specified records other than in limited circumstances under Section 25 of FIPA, but my office has always encouraged it, especially those records that are frequently asked for. The joint resolution of FPT commissioners I mentioned earlier calls on governments to do exactly that by routinely releasing significant public interest information related to policy making, public health, public safety, the economy, procurement, and benefits. The recent spotlight on proactive records release, of course, relates to briefings by BC's public health officer. Those disclosures have been both necessary and unprecedented. The approach taken has been at various points praised and at others criticized. I think what is also important to observe is that in the wake of this very public and for the most part respectful dialogue involving the public health officer, media, civil society, and other groups, the PHO has modified its approach to information disclosure as circumstances have evolved. We have seen this in respect of more granular geographical data, as well as changes to the disclosure policy on school exposures. All of this illustrates why constructive dialogue and openness on these matters is not only important, but I also think instructive for all public bodies to take notice of and consider proactively identifying and disclosing records that are both of public import and in demand. To summarize all of this, I would describe the state of BC's access to information system during the pandemic as one which has been stretched. At points, it has required making adjustments to its workings, and at other points, that system has been punctuated by troubling cases. But overall, my office has seen access rights and their importance both recognized and respected. None of this can be taken for granted. Ongoing vigilance by civil society, the media, the public, and oversight by my office are necessary to ensure the statutory access rights of British Columbians are respected and upheld. I want to shift now to a topic that, on its face, some might describe as decidedly dull, and I assure you it is not. And in fact, the topic at hand plays a critical role in a properly functioning access to information system. Here I speak of the importance of government having a robust record-keeping system and the need for this system to be subject to independent oversight. Good record-keeping is essential to good governance. We need to manage information properly so that it's available for sound decision-making. We have a duty to preserve information with historic value for our future generations. And it's vital to meeting the requirements of FIPA to have an effective access to information regime and to governmental transparency. And I'd also add that it supports good privacy management as well. With all that said, I find myself troubled about where we now find ourselves in regard to our record management systems in BC. Some of you may know that for a long time in this province, the organization and disposition of records was governed by the Document Disposal Act of 1936, a Depression-era law that only contemplated paper records from around the time they invented Scotch tape and the shopping cart. So clearly an update was long overdue. We pushed vigorously for much needed reform and government responded to a degree. The Information Management Act was finally brought into force in 2016. The IMA applies to government and court information and was intended to streamline information management and bring it into the 21st century. And in some ways it has. For example, the law now recognizes digital records and was amended to include a duty to document key decisions, BC being the first Canadian province to do so. Unfortunately, in a couple of fundamental ways, government got it wrong, and it's arguable the IMA represents a step backwards for information rights. Let me explain what I mean by that. The proper regulation of records management must include real consequences for non-compliance. Unfortunately, offenses for destroying records that existed in the Document Disposal Act were conveniently left out of the IMA. It should be noted that this is in contrast with Alberta's law, which includes penalties for these kinds of violations within their Freedom of Information Act. Without penalties, there aren't enough disincentives to improper record keeping. Another glaring weakness in the IMA is the lack of independent oversight, and I really believe this was a missed opportunity. The IMA created the position of Chief Records Officer within the Ministry of Citizen Services, whose role it is to approve information schedules, manage the digital archives, and promote effective information management. The CRO is also essentially charged with assessing compliance with the IMA by examining, evaluating, and reporting on the management of government information by government bodies and making recommendations considered advisable. So if you look at the CRO's most recent annual report from this past June, they've done a lot of work implementing the IMA, particularly in terms of awareness raising and information schedules. But when it comes to monitoring compliance, which as a regulator I think is pretty important, the CRO's priority has been to have public bodies assess their own compliance. I'm not suggesting these self-assessments are not useful exercises, and they can be, but they are not a substitute for a third party and a truly independent one to assess compliance, either in response to a complaint or proactively in accordance with risk. Even if the CRO took a more proactive role in examining organizations' information management practices, they are accountable to the executive branch of government. It's a self-policing system. And at least with the 1936 law, there was an independent oversight through the legislature. should say as a member, this was left off my bio, as a member of the Victoria Greyleafs Old Guys hockey team. And for those of you who don't or who know the sport, a lack of independent oversight is the difference between a hockey's preseason intra-squad scrimmage, where the teams essentially referee themselves, versus a regulation game with referees. Only here what we're talking about is a difference that impacts democratic quasi-constitutional rights. So we need to up our game. I am not suggesting that we throw the proverbial baby out with the bathwater or that we hop into a time machine and go back to 1936. However, I do think it's reasonable to expect legislative amendments that would result in a more robust framework. There are penalties in hockey, then there can be penalties for evading information management requirements. For example, those involved in destroying records. And there should be a specific oversight role for my office, like that of my counterpart in Ontario, to undertake independent reviews of government information practices. Without these elements in place, I'm afraid the current approach to records management in BC is not fit for purpose and ultimately diminishes the information rights of our citizens. This leads me to the final issue I wanted to raise in terms of improved oversight. My office exists to promote and protect the information rights of British Columbians, and we must have the right tools in order to do that. Modernization of both our private sector privacy law, PIPA, as well as FIPA, our public sector information and privacy law, is essential to do this. And now is the time to do it. This is the year FIPA is supposed to be reviewed. Meanwhile, there is a special committee in place to review PIPA. I do want to say that I think, again, owe a debt of gratitude to FIPA and other civil society groups and others here in the audience today, no doubt, who have joined in advocacy efforts to push for reform for both privacy and access laws in British Columbia. Let me share a few of the things we want to see in the new and improved public sector access and privacy law. I've already told you that we should have oversight over record-keeping practices of public bodies and the ability to impose sanctions for violations. Given the alarming increase of privacy breaches and cybercrimes, we must have mandatory breach notification, privacy impact assessments for mitigating the privacy risks of programs that involve personal information should also be required by legislation for all public bodies. Subsidiary corporations spun off by public bodies should be subject to access to information law. We continue to press the government on all of these points. There is an equally urgent need to update our private sector privacy law, drafted nearly 2 decades ago, before the advent of social media and when we were only speaking of telephones attached to the wall. BC's law is already out of step with the rest of our increasingly globalized world, and as is the federal privacy legislation. A world in which safe and secure data flows is critical to citizen trust and international trade. The Federal Personal Information Protection and Electronic Documents Act, PIPEDA, was found adequate by the European Union several years ago, thus allowing Canada to do more frictionless business with Europe. BC is part of that adequacy equation because PIPA is substantially similar to Canada's current federal law, a legal requirement. That is, until now, this adequacy, substantial similarity, Rube Goldberg type contraction was set up well before the EU raised the privacy stakes worldwide in a major way when they passed the General Data Protection Regulation. The world is advancing while Canada and BC sits on its hands. Other provinces are not waiting. Quebec just adopted Bill 64, a major modernization of privacy law, and Ontario is considering, for the first time, its own private sector privacy law. Canada must move on this reform front, like our colleagues in Quebec and Ontario. We in BC can't wait for the federal government to act. My office has offered a number of recommendations about what BC's laws should look like. I also want to commend FIPA for its strong advocacy on this issue as well. Our submissions share a number of elements. From my vantage point, the changes that British Columbians most require include private sector mandatory breach notification, and improvements to better capture consent. For example, notices that stand out in plain language instead of legalese. I should also note here, I'm particularly uncomfortable with some of the overly broad exceptions to consent that have been proposed and were proposed in the federal government's legislation last year. We also need to impose sanctions for non-compliance with the law. A modernized law should be better able to regulate automated decision-making. And finally, I would observe that many of the issues we deal with are borderless in nature, and regulation requires greater collaboration with our international colleagues. Amending FIPA to explicitly provide for entering into information sharing agreements would be exceedingly beneficial. Are we coming into a new era for information and privacy rights in British Columbia? I'd like to think so. I remain cautiously optimistic about the progress to come. I think it's fair to say there is a deeper appreciation among legislators, organizations, and the public generally about the need for reform in both the public and private sectors. That in no small part is due to the work of civil society and FIPA and others in this audience who care deeply about these issues. That said, now is not the time to take our foot off the accelerator pedal of reform. COVID-19 has hastened societal trends already in motion, from the explosion of digitization, virtual healthcare, to online schooling, to the need for clear and straightforward information to help us understand the world around us. All of it has underscored the evolving nature of our society and the fact that there now exists an even greater expectation for accountability by public bodies and organizations of all types and on a wide range of issues. We need to make sure that proper oversight mechanisms are put in place to ensure these public expectations are met so that British Columbians can have greater confidence in their democratic institutions. So with that, I'd like to thank you for your attention this afternoon and welcome the chance to hear your thoughts and answer questions in the time we have left.
So there we have it. I think a really compelling presentation, covers a lot of ground, touches on a bunch of really important issues. Now, in the live event, what we were able to do was take a pretty extensive Q&A period from our fantastic audience and raise a whole bunch of issues touching everything from vaccine passports and data security around BC's response to the pandemic and technology, through to questions about prospects for transparency, delays under FOI, and a whole range of other really important issues. If you want to participate in these kinds of events and in real time and join in these kind of Q&As, I strongly encourage you to become a member of the BC Freedom of Information and Privacy Association. You can find information about how to do that on our website. Of course, you don't have to be a member to attend these events, but I think people who are particularly keen on and interested in advancing information and privacy rights, this is a fantastic organization to join and to support. You could also donate to FIPA, and donations help us to put these kinds of events on, to organize public education, and a whole range of other activities. So this is my call to you. If these issues are important to you, and if you want to take part in and learn all about this kind of material, I really invite you to join me and to join others in BC who are part of FIPA and help us to do what we do. In what follows here, I'll talk a little bit about the organization, about some of our recent activities, and some of the ways that you can get involved. Thanks.
The BC Freedom of Information and Privacy Association is an organization whose mission is to improve and defend privacy and transparency as vital components of a free and democratic society. We envision public agencies who are transparent in action and decision, people in control of their privacy and personal information, and privacy and transparency embedded in law and policy. We're one of Canada's few advocacy groups dedicated to access to information and transparency and privacy issues. We conduct research into the public opinion, policy, and law that intersect access to information and privacy frameworks in BC and across Canada. And this includes monitoring the performance of public bodies, governments, and regulators in the sector. FIPA commissions studies and provides material that empower lawyers, journalists, students, and the public. In turn, we are frequently consulted on policy issues by politicians and government officials. FIPA's work encompasses legal research, public legal education, public assistance and aid, and law reform that focuses on transparency and privacy issues. If you're interested in these issues and you'd like to learn more, or if you'd like to contribute to FIPA as a donor or become a member of the BC Freedom of Information and Privacy Association, I encourage you to visit our website at fipa.bc.ca. You'll also find us on Facebook, Twitter, LinkedIn, and YouTube. Thanks very much.